Good morning, ma'am. You're Crystal Calvillo?
Yes, ma'am.
And Ms. Calvillo was previously in court and cause number 24 DCCR 2456 entered a plea of guilty to the state jail felony offense of theft of property. I've received that pre-sentence report. Any additions or corrections to that report?
No, Your Honor. No, for the state.
All right, ma'am, I'm going to find that you entered your plea of guilty previously freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 3 years.
Yes, ma'am.
You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity because you do not have the felony conviction on your record. And at the end of that probation period, if you successfully complete it, the case is actually dismissed and you will never have that felony conviction. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, you could be found guilty, and then you could be sentenced anywhere in the range of punishment, which is up to 2 years at a state jail prison. Do you understand? And there's no restitution, correct?
No.
Okay. All right, I'm handing you the trial court certification that shows this was an agreement that I followed, and so you have waived your right to appeal. If you'll just have a seat here in the courtroom, probation, she's going to call you up to her desk when she's ready to go over all of your paperwork.
Thank you, ma'am.
Good luck to you, ma'am. Thank you, sir.
Thank you, Your Honor.
Ms. Holmes, you've got a sentencing on Cameron Gutierrez. Sentencing on Cameron Gutierrez. Good morning. Good morning. Are you Cameron Gutierrez?
Yes, ma'am.
And Mr. Gutierrez was previously in court and entered a plea of guilty to evading arrest or detention with the use of a vehicle in cause number 25 DCCR 0325. I've received that pre-sentence report. Have you both had an opportunity to review it?
Yes, Your Honor.
Yes, sir.
Any additions or
And
corrections?
from the defense.
No, for the state.
All right, sir, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 2 years. You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation.
Yes, ma'am.
If you do that, this is a great opportunity because you do not have a felony conviction on your record. And if you successfully complete the probation, at the end of the probation period, the case will be dismissed and you'll never have a felony conviction. The other side of that, however, is if you violate any condition of probation, you can be brought back into court, found guilty of the offense, which would make you a convicted felon, and sentenced to prison for anywhere in that punishment range, which is between 2 years and up to 10 years in prison. Do you understand?
Yes, ma'am.
I'm handing you the trial court certification that shows that this was an agreement that I followed, and so you have waived your right to appeal. If you'll just have a seat here in the courtroom, probation's going to call you up to her desk when she's ready to go over your paperwork.
Okay.
Good luck to you, sir. Thank you.
Thank you.
Mr. Kelly. I lost Mr. Kelly. Mr. Mitchell, you've got John Van Wright, 2 cases.
Yes, Judge.
Good morning.
Good morning, how you doing?
Good, how are you?
Oh, I can't complain.
It's Monday. Nobody would listen if we complain anyway, right?
Drove in for Fort Worth to be here, though.
That's right. Good morning, sir. You are John Van Wright, and this is 24 DCCR 2485 and 15 23582. What is the announcement?
As far as the NTRP, it would be not true, Judge.
Okay.
So, you know,
I think we'll just prove up the MTRP first, Judge.
Okay, so let's do this then. Let me get that pulled up. We'll go through that entire motion, and then we'll get an updated report and set it for sentencing. Mr. Van Wright, would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir. And will he waive the formal reading of the motion?
Yes, Judge.
Mr. Van Wright, in clause number 1523582, I have a motion to revoke your community supervision. Shows that you were placed on probation July 28th of 2020 for the third-degree felony offense of injury to a child, elderly, or disabled individual, and that was a 10-year term in prison, but it was probated for 6 years. Is that correct? It alleges that you violated your probation. Count 1 alleges that you committed the offense of injury to a child, elderly, or disabled individual November 14th of 2024. And is that true or not true? All right, did you enter your plea of not true to count 1 freely and voluntarily? All right, then I'm going to enter that plea of not true on that count. I'm going to reset the case for sentencing hearing. About how long do you anticipate?
I want to know more than
About an hour or so, so we could do it maybe at the end of a docket. So we'll set it for 11, probably on a Monday, just at the end of one of these dockets, unless I can find a time when we're not in trial on another week.
Okay.
And that'll give y'all time for any
you can just
evidence.
let me know, or have Kelly or somebody let me know so we can get witnesses here.
We'll do it. She'll be back tomorrow, and we'll get that set in the next couple of days. If I can get an updated pre-sentence report, that would be great as well. And then we'll see y'all back at sentencing. All
Sounds
right.
good, Judge.
Thank you. We need to get his print, please. Yeah, make a note for Kelly, though, that it needs a hearing about 1 hour. We probably can do it on a Monday unless we find another day.
Yeah, I think it's Judge.
Yes, thank you. Mr. Rennick, you have a sentencing on Alexandria Bledsoe.
Yes, Your Honor, she's correct.
Sentencing on Alexandria Bledsoe. Good, how are you doing? Thank you. Good morning, are you Alexandria Bledsoe? And this is 25 DCCR 0004. Ms. Bledsoe was previously in court and entered a plea of guilty to the state jail felony offense of abandoning or endangering a child with intent to return. I've received the pre-sentence report. Has everyone had an opportunity to review the report?
Yes, Your Honor.
Yes, sir.
Any additions or
Only
corrections?
one minor thing my client would bring up. The name of her employer was Cigna, correct, or Sigma? Cigna, it was listed as Sigma, and she was just worried that that might be an
Okay,
issue. I told her not to worry
Don't worry
about it,
about
but
that.
she wanted to bring it to the court's attention.
okay, thank you very much. Anything else?
So, Your Honor.
All right, ma'am, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 3 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. That is going to include completing an intensive parenting class. If you haven't already done that through CPS, there's going to be something through probation that you're going to need to do, obviously. If you do everything that you're supposed to on this probation and follow all of the rules and conditions, then this is an excellent opportunity because you do not have a felony conviction on your record. The other side to that, though, is if you violate any condition of probation, you can be brought back into court, you could be found guilty, and you could go to the state jail prison for up to 2 years. Do you understand? Okay, obviously, I would like to think that this was a huge wake-up call because this could have been very, very bad. And so take care of your child, take care of the classes, make sure you make all of the right decisions when it comes to that, and you shouldn't have any issue. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. If you'll just have a seat here in the courtroom, probation's going to call you up to her desk when she's ready to go over your paperwork. Good luck to you, ma'am. Thank you, Mr. Rennick. And Mr. Rennick, you also have Patrick Gallagher
Yes.
sentencing, 24 DCCR 2422
Yes, Your Honor.
sentencing. Patrick Gallagher.
He's also present. And I have one other after that.
Good morning, sir. You're Patrick Gallagher? And Mr. Gallagher was previously in court, entered a plea of guilty to driving while intoxicated, third or more. And I received the pre-sentence report. Has everyone had an opportunity to review the report?
Yes, Your Honor.
Yes, Your Honor, yeah.
Are there any additions or corrections?
Nothing was mentioned.
I didn't see any, Your Honor.
So, Mr. Gallagher, you want to know what my big concern is? How long were you off probation for your DWI second when you got your DWI third?
I can't remember.
4 days.
4 days.
That's what it looks like to me. It expired, community supervision expired, looks like October 3rd of 2024 is the way this reads. New case, October 7th of 2024. What, if anything, have you done with regard to any kind of drug treatment? Anything on your own to stop using alcohol or drugs?
I quit drinking and I pray to the good Lord because I'm a single dad with grandkids, so that's over with.
Well, it should have been over with when you were on probation last time.
Yes, ma'am, I agree.
And I appreciate that you're praying, but sometimes that's not enough.
I agree with that too.
Are you still working
Yes, ma'am.
at Exxon?
Judge, there is one issue I need to bring up whenever you're done speaking.
Go ahead.
I'd spoken to the prosecutor about this. He is a full-time shift worker, and one of the issues was he had brought in his work schedule as he was, if the court was willing to, he had dates that he was not working to do the 10 days.
Okay.
And that is something I bring to courts.
Sure.
Oh, you weren't quick enough. You were quick, though. Okay.
It was the highlighted dates is when he is not working, that he was asking the court to. I know, he knows it's a big ask, but.
Well, I mean, I don't know. It kind of is. It kind of isn't. Typically, I let people who are working do it on weekends. This is just how the weekends
I have no
for his
issue with
weekends.
the erratic dates, Your Honor.
Here's the more, I guess, the part that's going to be potentially something that you're going to have to really figure out with your job schedule, and there's not going to be any excuses, is that you're going to have to enter and successfully complete the JCDI program. It is an intensive outpatient program. You're not the only patient that will have to do it on this type of schedule, but you're going to get started on that immediately without any mess ups, because if so, you're right back in here and you're going to be looking at going to prison. Do you understand?
Thank you.
So what I'm going to do then, Mr. Gallagher, is find that you entered your plea of guilty freely and voluntarily. Have you been wearing a drug patch either, or no? Was that a condition of anything? I didn't,
No, Judge, it
the
wasn't.
bond, it wasn't a condition? Well, because there was, the blood came back with positive of Delta 8 THC. I'm sorry.
That's correct.
Yeah. Are you doing anything like that still?
No, ma'am, I work for ExxonMobil.
Well, I mean, did you work for them when you,
I did, but I had a vape that I didn't know was there, so that's history.
you're 52 years old and you're using a vape that you don't know what's in it? Do you want me to buy that?
You don't have to, don't have.
I don't. Because if you don't know, then you should have known. So either way, it's ridiculous that, I mean, that's something that a teenager would come in and tell me, I got a vape and I don't know what's in it. All right, I'm going to do this. Going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time follow your agreement. Find you guilty of driving while intoxicated, third or more. Sentence you in accordance with your agreement. Well, actually, I'm not going to follow the agreement with regard to the length of time on probation. The fact that he was just off of probation, I think, warrants longer than a 5-year probation. The length of your probation period is ultimately up to me anyway, so it's not like I'm following the main part of the deal, but you still wouldn't have a right to appeal because that's up to me. So I'm going to find you guilty, sentence you to 10 years in the institutional division of the Texas Department of Corrections, but I'm going to suspend that and place you on probation for 7 years. You're ordered to follow all of the rules and conditions of probation. That's going to include entering and successfully completing the JCDI program and following, obviously, all of the rules and conditions. You'll have an auto ignition interlock device on your vehicle. Do you already have that? You're going to keep that at least for some amount of time. And if he has the interlock, you can make a notation. I don't need interlock and scram and portable, whatever they feel like is best through JCDI. Once that gets going, I'm fine with. I am going to order that you serve the 10 days upfront time. That is going to be on the date starting, I'm going to attach, I'll give you this copy as well, but so like where it says 9 nights, you work that night of the 9th. So you'll start on October 10th. I want you to turn yourself in October 10th at 6 p.m. And then you'll spend the 10th and the 11th, and they'll release you on the 12th. Okay? And then when you work days, what time do you get off?
4 o'clock.
4 o'clock p.m.?
Well, depends on when I leave, so it could be 4 to 4:30 to 5.
Okay, so the next time is going to be, since you're working days on the 16th, you're going to go at 6 p.m. on the 16th, and then you'll spend that night, the 17th, and get out on the 19th. If you don't have something written, days or nights, does that mean you're off?
We're so short-handed, it's a possibility, or I had to work overtime because I gave up 2 days overtime already for the 11th and 17th.
Okay. If it doesn't say days or nights on this calendar, does it mean you're off?
Yes, ma'am.
Okay. So that second one in October, you're going to go, we're going to get this done. Because that's your long days off. So we're going to get that week done. So you're going to go in on the 16th, and you're going to get out on the 23rd. So that gives you 1 overnight, 16th, 17th, 18th. That gives you 7 days. And then that first one only gives you 2 days. So that's 9.
So you're saying go in on the 16th when I get off work that day?
Mm-hmm.
Okay.
And we're just missing 1 day.
There's 7 November on the back of it there.
No, we're getting this will be done in December. So you're going to then go in on the 28th
Yes, ma'am.
at 6 p.m. and you'll get out the next day, and I'll take care of that last day. So, and then Anna will probably need that too. Make sure you get all of those done. Okay. All right. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rennick. You need to have a seat here in the courtroom and wait for probation to call you up. She'll call you up to her desk when she's ready to go over your paperwork. Good luck to you, sir. Yeah. What was it? $500 fine is obviously part of that as well. Yes.
Thank you, Your Honor.
Emily, thank you, Mr. Nichols. Emily, Mary Lockard Fury. Cause numbers 24 DCCR 1374, 1905, 1906 and 1907.
And Judge, I brought something, Judge, this has been the one with the federal
Yes.
issues.
Mhm.
And we had a proper meeting with the feds in early September, late August, for a day. I had informed them that this needed to be wrapped up because of what you had expressed to me in our last meeting. They have followed up with me and said that charges are imminent. And Judge, just to be very straight with you about it, they had told me that in June. And then I'd said, I'm getting heat respectfully from the courts, and she has charges also pending in chambers in Hardin County. The courts are aware of what's going on. Mr. Moran, the assistant U.S. attorney, has informed me that he thinks it's going to happen either, he alluded to me it's going to be in October, but I have no way of telling the court with absolute certainty that's correct. So I don't have any control over it because I thought it would be sooner.
Right.
But the dilemma for me is, and Mr. Smith, who's been super helpful and accommodating dealing with this issue, is that we know that the federal charges are coming. They haven't landed yet. But I don't want to be placed in a situation where I have no clean state
No,
charges and federal charges are coming. That's why I brought that email.
I appreciate the email. If you don't mind, I'm going to hang on to this.
Absolutely.
I might give Ray a quick email or a
Yeah,
call
and he's
just to
very-
find,
he's very
I've known him
pleasant.
we used to work together, so I'm fine with,
I've spoken with him, I've sent him all of the restitution amounts for our cases.
yeah. And he's probably, he may be waiting on other,
We had like a 6-hour proper meeting with the U.S. Attorney's Office. We have nothing else to give them.
Right.
We give them everything and each thing. It's really just waiting for, he's claiming a debriefing and the charge is coming, but it's taking
okay.
quite a time.
I'm going to do, let's do 45 days, reset, and then I'll email him or give him a call and just see if he can, if maybe that helps, or at least I can find out if it's, that they're waiting on maybe other agencies that y'all don't have any, or you don't have any access to, if there's other counties involved.
In the first email that's on there, you might notice that I was getting heat from Jefferson County, but it's Judge West.
No, I saw, I saw that. No, I'll give him a call and see if I can get some more information, and then we'll hopefully get some answer between
If
now
I
and
know
then.
anything, I'll call you.
Okay, thank you. All right, you're free to go. 45 days. Thank you, Mr. Rennick.
The courtroom opens with routine greetings, but the tension rises fast. Crystal Cavallo stands before the judge, accused of felony theft. She already pleaded guilty, and today the deal is revealed. The judge defers proceedings, grants 3 years of probation, and explains the stakes with surgical clarity. Follow every rule, and the felony vanishes. Break one condition, and prison becomes real. Good luck to you, ma'am, the judge says, and the warning lands harder than the mercy. Next, Cameron Gutierrez faces sentencing for evading arrest with a vehicle. The judge repeats the same promise and the same threat. Probation offers freedom without a felony, but violations flip the switch to years behind bars. Gutierrez nods, understanding that this courtroom rewards compliance, not excuses. Then the tone darkens. John Van Wright appears on a motion to revoke probation for a prior injury to a child case. The judge administers an oath, recites the allegations, and schedules a full hearing. The message is unmistakable. Truth will be tested, evidence will be weighed, and time is short. Raise your right hand, the judge orders, turning a procedural step into a moment of dread. Alexandria Bledsoe follows, pleading guilty to abandoning or endangering a child with intent to return. The judge accepts the plea, orders probation, fines, and an intensive parenting class. He calls it a huge wake-up call, urging her to choose better decisions. The courtroom listens as compassion pairs with consequence. Patrick Gallagher's case detonates the room. A repeat DWI defendant, he admits his probation ended just days before his third arrest. The judge probes treatment, work schedules, and a positive THC result. Gallagher claims a vape he didn't know contained drugs. The judge snaps back, calling the excuse ridiculous for a grown man. Then comes the reversal. The court rejects part of the agreement, imposes a suspended 10-year sentence, stretches probation to 7 years, orders jail days, an interlock, and intensive treatment. If you mess up, you're right back in here, the judge warns, mapping exact surrender dates with unforgiving precision. Finally, a sprawling fraud matter pauses as federal charges loom. Emails are reviewed, timelines reset, and a 45-day continuance is set. Even without a verdict, the gravity is clear. Across these cases, instant karma isn't shouting, it's structure. The judge offers chances, explains risks, and enforces reality. Mercy exists, but only for defendants who follow the rules. Ignore them, and the courtroom turns silent, then decisive. Viewers watch power shift as calm explanations replace theatrics and outcomes hinge on choices. Each sentence clarifies law, limits, and leverage. Probation is framed as privilege, not entitlement. Paperwork, fines, classes, patches, calendars, and signatures become instruments of accountability. The judge's tone never wavers, but consequences escalate. Defendants learn that sincerity matters less than compliance. In this courtroom, fairness is consistent, patience is finite, and justice arrives without spectacle, leaving silence, clarity, and consequences in its wake. Those lessons linger long after the gavel falls, reshaping futures through disciplined mercy and relentless enforcement of clear judicial boundaries.